I'm really looking forward to this panel of independent directors. This has been a raging issue over the last couple of months and years, and so I'm glad we got an all-star panel for it. Let me turn over to the moderator, Didier Seffer. Didier is the managing director over at Riveron, and he leads the strategic advisory of financial institutions and corporate clients in complex in-court and out-of-court restructurings. He has 30 years of experience, and thank you for putting this panel together.
Sure. Thank you very much. Thanks, Harold. Okay, very good. Thank you all for joining today. I would like to just start the panel with introducing my colleague panelists here on the panel. First, we have Madeline Primov, more than 20 plus years experience in the restructuring world. I'm sorry. She's with Freshfields, Brookhouse, Derringer. She's been representing primarily creditors, ad hoc committees, cross-border filings, or other court restructurings have also been a focus. So she's very well versed with all the problems that come around the bankruptcy filing or restructuring. Then we have Sherman Edmiston, who has a lot of experience, more than 20 years too. 30? Yeah? No names? No numbers? 20 plus. 20 plus. How about 20 plus?
Somewhere.
Okay, 20 plus years of experience in the restructuring world, previously at Zolfo Cooper, now an experienced independent director in many, many cases where he's being retained. Following him is Ray Schrock, who is currently with Weil Gotshal, co-chair of the restructuring department. Many years of experience also in restructuring, has written the book on a couple of things, a couple of strategies, and is certainly very well versed with all the challenges that come with appointing independent directors, with working with both creditor and debtor constituencies and private equity holders. And then last but not least, we have Patrick Bartels, coming from the buy side, with many years of experience also on the distressed side, investment, now also an independent director who has many cases under his belt, also been faced with a lot of those issues that we want to debate today. So I foresee actually a quite exciting panel today. I think we're going to have forceful views, we're going to have divergent views, which is on purpose. We want to make sure that we debate the issue today. We may not come to a full conclusion about what the right way forward is, but we certainly want to highlight what is going on and the challenges that independent directors face in today's market. Without further ado, we're going to launch into it. And I'm going to start with just an introductory question for our counsel, esteemed counsel here present. So we're going to start with, let's define first, what does an independent board member mean, and when does it make sense to add an independent director to the board? So Madeline and Ray, if I may ask you to get started.
Much of this is defined by reference to state law, the federal securities laws, and stock exchange listing requirements. So public companies typically have a majority of their directors are independent directors. So an independent director is somebody who's not the sponsor, not management, not an auditor. It's somebody who's not deriving revenue or income from the company itself. And as to when to add an independent director, could be if there's in case of a conflict, so a conflict with the sponsor, if you need to negotiate a settlement of claims against stockholders, if you need to negotiate a transaction with the sponsor, such as a sale of assets to the sponsor or a new infusion of capital from the sponsor, you may want to have independent directors. Well, you do need to have independent directors. Sometimes lenders have an opportunity, depending on the flow of traffic and what their documents provide. The lenders may come in and say, we're only willing to give a waiver or a consent if you appoint independent directors. And it may be that the board itself recognizes if a company is entering a period of stress or distress, that it needs to add expertise to the board. And that expertise, it may be operational expertise, it may be financial, or it may be that you have a board who hasn't been through a period of stress or distress, and they want to bring in somebody who has those credentials.
Yeah, I agree with all that. I think that, generally when I'm thinking about putting on a new board member, sponsor conflict, that's an easy one. If there's something where you're seeing distress on a private company, it's not uncommon for a private company to have all interested directors, and having somebody who's independent, not just by SEC standards, but also in stock exchange standards, but also is, listen, they're independent by appearance and actually. So somebody who really doesn't have a connection to the sponsors, to the company, the closer questions are, you have a board member that has been on another board, frankly, with another sponsor portfolio company. Those are things you certainly have to watch out for. If there's, how many, other transactions have they been involved with, and who are they have been involved with? And I think as, we look at people undergoing, a greater degree of scrutiny, sometimes in court and by creditors, we'll continue to focus on the independent nature. But it is absolutely, having lived through many restructurings with companies without independent board members, and then having somebody who actually knows what they're doing, in the boardroom and has been through it, I can tell you the value I think that they bring to the table is pretty extraordinary. And I think it helps not just for the, obviously there's legal protections that come with having somebody who's independent, but I think it's also helpful to have somebody there, frankly, for the other board members and for the management team as well, to have some experienced people in the room.
Thank you, Ray. Thank you, Madeline. Next question would be, when appointed as an independent director, how defined is your role, and how can independence best add value? So we're going to delve a little bit into that. And what are the risks and challenges of serving as an independent board member, and under which circumstances, if ever, should independent directors have access to separate advisors or counsel? So we're going to maybe start on the latter part of the question, when should they have separate advisors or counsel? And then what is it really, what are the challenges and the risks that an independent director may face when appointed? Madeline, do you want to start maybe with the latter part, which is when would you recommend separate counsel for the independent director? And then we'll turn it over to Sherman and to Patrick for the report.
So depending upon the circumstances of which the independent director is being appointed, I mean, if it's a conflict situation, then in effect they're performing as the role of like a special committee, and they want to have independent legal advisors and maybe financial advisors as well, and that protects both the independent directors, but it also protects the rest of the board, because the board wants the benefit of business judgment rule. They don't want the transaction to default to an entire fairness standard. So you want to, both have the independent directors really be independent and have independent advice, and you also want to have the appearance that it was independent and that they had access to proper advisors. On a day-to-day scenario where it's not a specific transaction that they're being brought on to consider, then if I were an independent director, I would want to have the access to advisors. It may be that you don't need to call upon your own advisors, and certainly the independent directors can make that decision for themselves, but they should certainly have access to their own advisors.
Thank you.
Just to add just a couple things that I think that, when you're looking at the appointing resolution for an independent director, first of all, like practically and legally, it's always critical that they have the ability to hire their own counsel if they deem it necessary. Practically, where do we see it come into play? If for instance, Weil Gotschal's debtors counsel, we're coming into the situation, we're brand new, and the independent's coming in relatively contemporaneously, I'd say it's less frequent that you see independent counsel, depending on what they're doing. But if there's a review of transactions in which we were involved, you almost always do. And frankly, it just depends on the contentious nature of the situation. If they're there to do an investigation, I would typically see them, have independent counsel.
As the independent, it's not my predisposition to come in and seek my own counsel or financial advisors, because you want to keep the process moving along, you want to keep the costs down, but having the ability to do it in certain conflict situations where you're sitting at a subsidiary by yourself, where you're on a special committee there, having that ability is incredibly important. But you have to be speaking with the debtor's counsel who's running the process to make sure that there actually is a conflict. I've seen it both ways in independents. There are some independents that absolutely demand their own counsel and financial advisors. Most of the time, not for the right reasons, but sometimes it is for the right reasons. But we absolutely have to have the ability to do it to maintain the integrity of the process.
Yeah, but if I'm sitting in a different legal entity,
Yeah, yeah.
and ultimately, there's going to be transactions that need to be negotiated between my entity and maybe the parent company, right? I'm always going to insist, that I have my own legal and financial advisors, always.
And what would you say the risks and challenges are in maybe not doing it, or alternatively in doing it for the wrong reasons? I'm just picking up on Patrick's comment.
Well, I mean, when you talk about the process, you want the process to have the integrity. And if you don't have your own advisors, you just open yourself up, for somebody to assail the process and say, well, there's a creditors committee that's looking at the transactions and saying you didn't investigate it properly, or you're doing an affiliate transaction that hasn't been vetted, and that having that additional layer of protection, when you're looking at it from the point of at least legal counsel, but sometimes financial advisors as well, it's just you're weighing that, between the two of the cost and the speed or the alacrity of the process. But Sherman's right, you absolutely have to have it in certain situations where you're actually sitting in a different box, or there is, not even the appearance, I would say appearance of a conflict present. You just don't want to take the risk because slowing the process down will cost way more than actually introducing other advisors into the process.
Fair
Right,
enough.
but it's just simple, right?
Please.
If the information that you're getting is not independent, then it's hard to argue that you're an independent director, right? And that's why you need your own, legal advisors or financial advisors in various situations.
I've seen independents come into a situation not even understanding the situation and demanding their own counsel. For what reason, I have no idea, but other than the fact that they just wanted their own counsel.
Fair enough. Let's dig a little deeper on that. So one of the most important duties of being appointed to a board as an independent director is to bring a proactive yet reflective and independent point of view and opinion to a process that may be starting or be on the way or may or may not happen. In your experience, what does it mean to be appointed as an independent director in a distressed situation? More precisely, are you typically brought in with the mindset, I'm here to help turn around and restructure, or are you immediately, tuned into the bankruptcy mindset of how do we achieve maximum value for the stakeholders in this distressed situation?
It has to be the latter. You have to look at all available options, right? You can't go in with a predisposition of what you're going to do in the case and say, we're going to just restructure. You have to go in with the advice of your advisors and say, what are my available options? I mean, the answer may be evident right off the start, but you have to go through the process of looking and foreclosing all the options before you make that determination as you're discharging your fiduciary duties. And when you're looking at the independents that do that, you want an independent that will go on to a board and work, as Ray said, work with the other board members because they'll have more questions than not. And when you look at the independents, I always thought about bucketing what makes a good characteristic of an independent. It's obviously in independence, not just appearance, but in actuality. And then when you think about it, they've got to be competent. They've gone through the process because we all know the process can get away from certain people who don't understand it really quickly. I can go to a foreign country and say my name and order a loaf of bread, but then within 5 minutes, it's completely away from you. And then the level of engagement where you're just not there for board meetings, you're willing to speak to the advisors, you're willing to dig in, you're willing to speak to the other board members that have questions either in a formal setting or an informal setting. And then lastly, I think a lot of people have struggled with this with independence is availability. Some independents dictate the process because their schedule overwhelms sometimes the process, and that availability is utmost important, especially when you get into the moments of deals, when you're actually looking at the restructurings and doing them.
I would say, and it also depends on when the director's coming into the process. I mean, sometimes you have situations where, and I'd say this is becoming more common in my experience, where if a company's running into liquidity issues, and you have this, right, we have all these covenant light loans out there, and there's really, people aren't realizing there's a problem until there's a real liquidity problem. And if you end up having to go to a set of private lenders, and they're willing to put in some kind of rescue financing for the company. Sometimes what comes with that is, and by the way, especially if it's a private company, we want you to put an independent director on the board. And I think that that's something that you'll continue to see as creditors are saying, listen, I want to be involved, I want to support the company, I want to have an investment, but I want to make sure that the company has independent board members and somebody who's looking out for all stakeholders on there. And I'd say in those situations, and Patrick and I have been on deals where he's come in, at the behest of creditors. I think that mindset, one, it's talking to your client and helping them understand. Listen, this is not like having a lender that's in the room. This is a real board member, somebody that's going to take their fiduciary duties seriously, but somebody that also, I think, if you ever have to go to court and you're trying to defend a transaction, the fact that the creditor is actually insisted they're coming out of the board is extremely helpful. So, but each one of those circumstances, can affect, it depends on, the circumstances leading up to the loan, whether or not you have or need independent counsel. But I think it focuses on what's the primary purpose of putting them in there.
Yeah, I want to add, you hit on it, but I want to go into a little bit more detail. I think one of the things that where independent directors add value, quite frankly, is their relationships with a broad spectrum of the constituencies who are involved in the typically involved in the restructuring bankruptcy process. So I would think, let's say for myself or Patrick, relationships with sponsors, relationships with law firms, relationships with advisors, relationships with various creditor constituencies, secured bondholders, relationships with other independent directors, and relationships with management teams, right? When someone is brought into the process that has that broad network of relationships across the spectrum, I think it gives the process credibility.
It also helps break log jams.
And definitely.
In certain points, you can't have the independent out in front of the advisors the whole time, but if you need to, take a measure where you've reached an obstacle, it feels like it's insurmountable, let's bring the independent in to give, an objective view on how the process is going, that they have credibility because the relationships are there, it does seem to work fairly well.
Right, and there's many times I've had to break the logjam in negotiations, or we've come to a decision as the board. We've delivered that message to a constituency, and I've said, guys, these guys are all going to call me, later on tonight or tomorrow, right? So one, I need the approval to be able to talk to them, and we all need to be on the same page about what I'm going to say to them, right? And the fact that I had the credibility that when I say X, they trust that it is X, right? I think can be very helpful in processes.
Thank you. Okay, very good. Thank you. We're going to go a little bit back up from the details we've been in right now. We're going to talk about the bankruptcy law. It actually strives to protect both the debtors and the creditors, the businesses, but also the creditors. Do you believe that shareholders, when they actually appoint an independent director, are sending out a message with that appointment, maybe a few months before restructuring happens, either in or out of court, that it signals to the creditors that there may be, a somewhat biased creditor process that is about to happen? And I'm going to try to get Madeline and Wade to answer first before the independents respond to that, because it's a bit of a needling question. Go ahead.
I don't think it's biased, but I think it actually says that companies get good advice and knows what the hell they're doing. When you have a private company and a company is having financial distress, it's only, listen, every creditor who is going to take a hit is going to look for where's the deep pockets and where's the exposure. This is the business, of any restructuring. And if I'm representing a creditor, certainly that's what I'm going to look at. But having somebody come into the process, does it send a message? Absolutely, it sends a message. I think it sends a message that, okay, there's a need for an independent director here for some reason. It could be financial distress. It could be, creditors organizing. It could be at the behest of creditors. I don't think it's a structural bias. I think, frankly, that's the law. The law, sorry. Yeah. Is that better? Wow. Okay. Okay, let me start back at the beginning of the panel.
Don't you dare.
Right. I thought I was speaking loudly. Okay. Wow, I can hear myself better too. But I think that it does send a clear message that one, that I think they're being properly advised. Two, that there could be a potential here for distress. But the law underlying who selects directors, it's bound by state law. This is our process. They have a shareholder, a controlling shareholder, and subject to the agreements that are in place, has the right to appoint a director and to put them into the process. Do I think it's a structural bias? No, but I think if state legislatures want to change who changes directors, I'd like to see how that argument actually goes along. But when you think about it, the entire premise of, and I don't want to get into other issues yet, but the entire premise underlying our system of Chapter 11, which is the envy of every single other system in the world, is that you're giving companies an opportunity to reorganize, that you're building a company and you're not turning over, like you do in several other foreign jurisdictions, you're not turning over the company to creditors immediately upon there being first signs of distress.
Madeline?
Yeah, I agree with all of that. I mean, it is a bias, and it's a bias regardless of whether there's an independent director or not. Make no mistake about it. Restructuring in the U.S. it's a shareholder-led process. It's a board-led process. Nobody should be surprised by that. We've entered an era where there's unprecedented levels of liquidity in our markets and our capital markets. If creditors want a different system, then they can draft their credit agreements and their bond indentures to contain covenants that would give them all sorts of protections. But we find ourselves in this situation in part because the world has shifted to no covenant or covenant-light deals, and then we get to a point where the sponsor's got some level of distress and wants to appoint independent directors, and people say, there's a restructuring going on here. Well, but if lenders want to check against that, then lenders should put covenants in their documents so they get earlier warning signs.
Right, although I would say that it's putting provisions in the credit agreement that allow them to pick board members or consents for bankruptcy. Those are things I think we'll continue to see. As people probably press this issue, we'll see those litigated. There's already some Third Circuit law on those issues. Creditors having the right to prevent somebody from filing for Chapter 11, but I'm sure we're just at the very early innings of this.
Yeah, I agree completely, but there's plenty of things that creditors can do in the way of old-fashioned covenants to get earlier warning signs of when a company is entering distress or stress, and creditors have gotten away from that over time.
Yeah, the current market just clearly doesn't support that.
Yeah, I mean,
That protection, but it might.
They opted.
They are opted
right,
to relinquish those rights.
to give up those rights.
Yeah, that's right. All right, let's continue with.
Many instances
Yeah,
when
but
they traded in it, sense of
The way that
Go ahead.
loans are structured now is completely different. First lien, second lien was lien priority, but it was almost like payment priority.
Yep.
That changed, probably about 10 years ago,
Mhm.
right? And now you have the deal, and then you have the birth of, we haven't even talked about it yet, of private credit and direct lending. They have the ultimate, they put proxy rights in the documents where they can sweep the board or, sweep the cash, which puts them in control right away, but you usually don't get there until the liquidity is in a dire state, right?
Yeah.
Right, that's in a negotiated transaction.
100%.
Right, and it's very situational, right? And you've arrived at a point, right, where the company needs capital, and there's and advisors have gone out and canvassed the world for capital, right? And they've come to a party who said, I'm willing to provide you capital, but I'm willing to provide you capital on these terms, right? It's a negotiated, not mandated, right? And I think that's a really important point.
100%.
Yeah, and it usually would be for a company that would otherwise not have access to less stringent conditions of capital, right? It's a negotiated solution because you get the money only if. It's not a normal day-to-day bank-led syndicate.
The world
it's
changed,
different.
right? The world
Yeah.
is very different than than it was when they first went out to do the syndicated
There
financing.
you go. This is the replacement.
Right.
Yeah. Yep.
It's a different
If
one.
you
It's a different
barbell-
world.
You
Yep.
barbelled it, the public companies are gonna have the issue about when independents come on and how they come on, and then as well as large syndicated loans. The private credit, the mechanism's there already.
Yep.
Like, they can do what they want, then they'll negotiate a forbearance, in comes the CRO, in comes the independent director.
Yep.
The syndicated loans, as well as the public companies, are the ones where the creditors are gonna have more influence, and that's where you're gonna see. But, the state law aspect is, we're gonna get into whether creditors should have approval rights, but we'll go there.
I think it's a really important point that this, there's already, in many of these private credits, there's an instrument,
Yeah.
the proxy rights and share pledges for creditors to put board members on. And we don't always see creditors do that because they get concerned about lender liability issues and, how does this really work? But, having, advised a few creditors and have gone through that experience, I mean, listen, it works. A court's going to respect a share proxy, a share pledge, most of the time, providing there's an underlying default, that I would say it should be a good default, not a reporting type of default. That's a tough one, I think, where, sometimes you're going to run into issues in courts of equity. But there's instruments already there. They're just not being utilized, I'd say, on many larger cases where, there's almost always a share pledge in a fully secured loan.
There's a business implication, though, for the direct lenders and private credit. They don't want to get too aggressive with their sponsors.
Right.
Because they want to continue, they're serially issuing the loans to their portfolio companies for the sponsors. And if they get too aggressive, they may lose their relationship. And they're deploying massive amounts of capital because liquidity is so flush right now and has been for a longer period of time.
And a lot of funds, even if they had those rights, like you said, the willingness to use those rights, right, comes into play. And also, most funds really don't have the time to sit on these boards, right? So they want there to be, I think, a viable roster of independent director candidates out there to choose from, right, who can fulfill the role that they are, oftentimes do not have the time to fulfill on their own.
Thank you. I think I'm gonna.
Go ahead.
Thank you, guys. Because that's a good segue to our next kind of topic and question, which is really the meat of things. There was a study recently called the Rise of Bankruptcy Directors, which claims that distressed companies, especially those controlled by PE shops, right, prepare for Chapter 11 by appointing bankruptcy experts, independent directors, giving them the board's power to make key bankruptcy decisions. And the white paper alleges that there is structural bias there because the independent board members in question, in order to secure future appointments with the PE or law firm that they work with, will try to please the clients, maybe at the expense of creditors. So this is straight on for Sherman and for Patrick. This is the meat of the matter
Look,
on that white paper.
so I guess my first response would be, the question I would ask is, maybe in the sample set that they're comparing to where there wasn't an independent director, maybe the unsecured creditors actually got too much, right? And so when you're comparing, you're not comparing apples to apples, you're comparing apples, to oranges. So that's number one. But number two, I would say, I'm not really aware, of instances in which law firms or sponsor firms are looking to hire people who are going to be shills or rubber stamp transactions. I think they are looking for people who are going to lend credibility to the process and people who are going to help drive the situation to a solution that's the best possible outcome for everybody. So I understand the paper is, has gained a lot of attention. I don't really think that there's a lot there, but that's just my opinion.
Patrick,
I've read the white paper multiple times, and I tend to agree with Sherman, and the points that Madeline and Ray raised about why you're bringing in an independent, ring true here, because when you get into the process, the lawyers that have the restructuring experience are quarterbacking work. They're the maestros of the process. And it's up to them to have service providers like independents join the process to provide leverage to that process. It just so happens that if they bring the right people in and those people perform, and hopefully the sponsors don't have that many situations where they need independence because they're evaluating some sort of restructuring, that if these people do a good job, it's just logical that they would come back to the same people, not only the lawyers, but the independents, and say, this was a good process, you worked us through it, why wouldn't we go back and have these people come to work on another company if we do have a situation like that, right? From my perspective, they've had in the report, they were trying to quantify how much the creditors had suffered for independents that had come in. I have evidence whereas certain sponsors or management teams would say, we couldn't have done this process without the restructuring lawyers and the independents here to guide us, and we feel like we actually got through this quicker. It was less expensive, and the value of the enterprise was higher or maximized as having people in.
So how do you ensure, just to follow up on that, how do you ensure that your actions are actually not just are independent, but also perceived as being independent so that you don't really fall into that trap?
Let me answer that first.
Go.
Okay.
Sorry, sure,
So, because I'm actually prepared for this question. So first, what I would say, the way I look at it is, first, you need to have a moral and ethical compass, right? I think that's number one. Number two is, you really have to Patrick's point about availability and time, you really have to have the time to devote to this process because you need to dig in and make sure that you obtain all the information that you need in order to make wise decisions, right? That means, you have to be as informed as possible. You have to ask lots of questions. You have to challenge assumptions. And it's always better if as a director, you have familiarity with the industry, right, or the sector in which the company operates, right? And I just think the last thing is you just have to run a transparent process, right? If you run a transparent process where your advisors, are negotiating in good faith with all of the advisors from all the various constituencies, right?
So
Then I think with those three things, you can eliminate most, if not all, people's concerns about bias.
let me need a little more, right? If you truly believe what you said, right?
I truly believe what I said.
And I do. I believe you, right? But for this discussion, right, would you think it would be good for the independent directors to be subject to some kind of approval process by the creditor constituency, not just by the shareholders?
Sure.
Hypothetically.
Go ahead.
I'll take this. The answer is no.
Yeah, that was my answer.
The answer is no.
And why?
Because we have a process, and the process works very well. Yes. Are there perceived weaknesses in the process related to the fact that perceived out of the money sponsors are running the process, which may be to the detriment of the creditors? However, the creditors are now wanting to bring in independents that they're working with the law firms or they're proposing with the law firms. And the fundamental shift here, while it's working now, is that when you started in the early 2000s, certain firms, whether law firms or banks or financial advisory firms, had roles or sides of the aisles that they would sit. They would either be debtor side firms or creditor side firms. Now, most firms are doing everything either debtor or creditor, and to their own detriment, if they don't work with both sides, it hurts their practices. So they're more willing to say, let us think about what the creditors want here. Give us a list of names that are acceptable, that they think can come into the process and have the attributes that Sherman's talking about, the competency, the judgment, the integrity, to do the good job, run a transparent process where all the advisors have conflict, but out of conflict comes creative solution. And that's what's happening now. That's a fundamental difference, is that everybody's doing everything for everyone. And it would hurt Ray if he had a creditor side lawyer that does predominantly work with funds, if he says, we're going to run the quote unquote debtor side playbook here for the sponsor. It just won't work long term. It's not viable for the right outcome in the situation or the right business choice for the firms involved. That's probably one of the biggest changes in the industry that I've seen in the last 5 to 8 years.
So I think, there's when you look at like what are we talking about here? We're talking about the people that I think are upset about independent directors. It's not the private lenders, it's not the banks, it's, I think, unsecured creditors. I think those are the parties that come into a case, and sometimes they're the last to know. They're the last to be brought into it. Sometimes public side bondholder groups, I also see, that gets to be director selection is a, contentious issue. But, we have a system of laws, state laws that talks about who gets to pick the directors. We have a Chapter 11 process where there's already scrutiny. I mean, if people don't think there's strict scrutiny over directors, I'd submit you haven't been in court recently. Because there's very strict scrutiny. The judges are absolutely, in any time you have an independent director, they're looking into what's their relationship with the debtors' counsel, what's their relationship with the creditors. Are they here doing somebody else's bidding? And so I think from that perspective, it absolutely works. I mean, the alternative to not getting an independent director is, what, are you just going to have entire fairness, review for every one of your transactions? You're just not doing your job as a lawyer if you're leaning in that direction. But obviously, and I'll just say, I disagree with the paper. I know it's shocking to everybody, but that's my
Look, everyone has relationship conflicts, right? People who are true professionals understand how to manage them. And I'm asked plenty of times when I'm interviewing for boards, about my relationships. And my relationships are extensive. And my response is, if you hire someone that doesn't have the extent of the relationship conflicts that me or some of the other people who are interviewing for this position have, they're probably not that good, right? That's the reality of it. And the last thing I would say is, there's plenty of times that I would get hired by the debtors, and then I get calls from the first lien creditors, the second lien creditors, and the bondholders saying, we're glad you're involved, right? So to your point, right, I think that people don't look at it necessarily as bias. They look at it as you're ensuring a competent, fair, and equitable process. That's my point of view.
They're trying to guard against the roster of directors that have been around for a while, that haven't had the best outcomes in cases, and now that shift has happened. But Sherman's right. Once people are involved that know you're involved, it's never stopped anybody in the restructuring world from calling anybody.
Mhm.
I mean, working the phones is part of what we do.
So I think the market, I think the market clearing mechanism, right, in this process is very effective. So I don't believe that it's a process that should be mandated. When it's negotiated, that's fine, right? I think so, negotiated, not mandated. And I think if you had a mandated process, one, I think you'd be increasing the complexity of the process with probably very little added value. And I think there's also the law of unintended consequences, and you'd probably end up creating more apparent conflicts than you would actually solve for.
Don't forget to not flip this on both sides. I mean, you're talking about debtor side. You could bring an independent from the creditor side that could be equally disruptive. I agree with that. Whereas that they're just not commercial, they're not collaborative, and they're not willing to dig in because they're just, I'm here for what's best for the creditors, when they haven't done the work to know what's best for the creditors.
So you actually answered the question I wanted to ask, but you already answered that question, which is really good about the self-checks and the current ecosystem, whether or not self-regulation is sufficient. When you listen to Washington, at least some voices in Washington, they disagree with that position. And hypothetically speaking, they think legislative action should be taken to put more onus on the independent directors to be selected by a wider group of the constituency, not just the shareholder-led group or the negotiated, usually secured creditors, but also give a voice to the unsecured. So I'd like to hear some voices here around the panel about, yes, there are laws of unintended consequences, but is there a better way? If so, what do you think it would look like? And if not, what do you think Washington is going to do? Anyone who wants to pick that one up? Maybe Madeline? first go?
Well, I think that based on the state law, prevailing state law, there are ample ways to challenge a director appointment if people want to. I mean, there's, every case that we all see has, depositions about, it's basically a proctology exam into the independent director's connections to everybody in the case. So just using basic state law, there's an ability to challenge the disinterestedness of directors. I mean, one of the things that we should think about is whether for transactions where the independence of the independent director is questioned, without declaring the independent director to be interested, you could raise the bar on settlements, for example, and say that rather than have the test of a settlement be the lowest rung of reasonableness, you could just make it a reasonableness, business judgment test. So elevate the standard for approval of a settlement. Because it is a tough pill for creditors to swallow. If there's a perception of interestedness, then you've got, the dual hit of, okay, I think there's a perception or an optic that the directors are not completely disinterested in. And then on top of that, a settlement is being judged under the lowest rung of reasonableness.
Yeah, and I mean, the judges all have the opportunity to look at those issues, but, I think if you start altering who selects directors and start picking favorites, one, it undermines the whole notion of what being an independent director is. Okay, there's only one group, okay, and those are the debtors' representatives under our current legal system that have a fiduciary duty to all stakeholders, not just one group. So you start having one group select or another group select, I think that really skews it. And I will go back to it again, that Chapter 11 is the only system in the world that runs, it's a debtor in possession system. The debtor stays in control of the company. The debtor gets a chance to reorganize the company. The debtor gets a chance to make the best they're the ones who are in the mess. They have to figure out the best way and kind of balance all the competing views. And I think it really undermines plan exclusivity, debtor in possession, the notion of being a fiduciary for all stakeholders when you just have one group that's picking directors. I mean, these guys will tell you, I'm sure, once you get on the board, you're in it, okay? Like, you may have been selected there, but you are going to have to do the right thing for the company. And so I think it's easy to cast stones at the current system. I believe that many bankruptcy court judges think that the system works quite well, that there's an efficient system for overseeing it, and what the directors are doing there. You're in court. I mean, anybody can challenge. You got 2004 discovery. You've got a motion for an examiner. Easy things that people can do if they think that there's a problem.
How about cash collateral or dip budgets?
Hold on. Okay,
But
let's
ask a question. Which creditor constituents, under a mandated scheme,
yes.
which creditor constituency would get to choose? If it's the first lien creditors that get to choose, the second liens are gonna be, pissed off, right? If it's if it's the first and second liens you get a chance to choose, then the bondholders are going to get
The unsecureds are going to be upset.
right. Yep. So, what would actually be the process of actually arriving at what creditor constituency gets to select these mandated directors?
You're making a predetermination about who the fulcrum creditor
Yeah.
is.
That's
In
you're
a
shifting
debtor-
you're shifting the power. You're shifting the power
Yeah.
from the debtor to a group of creditors. But this is exactly what we're hearing out of Washington, that should happen. I don't agree with that necessarily, but that's what the rumors are, that there is a need for that shift.
And I think we're just pointing out all the ways in which that's probably not really practical.
So are we saying Washington doesn't know what they're talking about?
That wouldn't be the first time.
No surprise. When it comes, even though some people making those noises are actually bankruptcy experts in Washington currently, they're elected officials, I have to admit. Maybe.
I don't know. I wouldn't want to be an independent director in Germany where I'd be personally liable. So I like our system. I think it works, but it has some pitfalls that we have to navigate.
Before we turn it over for a couple of questions, any closing remarks for this topic, and then we just want to open it for a couple of questions.
I'm a big believer that you just can't legislate human nature. right? I think an independent director's moral compass, right, and ethics, by and large, is going to be tested, and it's checked by the market, right? If you're considered to be a shill or biased or incompetent, right, then you're not going to really be able to be an active participant in like this market for independent directors, right? You will get flushed out.
Okay.
Yeah, I don't think that this is a Chapter 11 question per se, because the independent directors, more often than not, are brought in advance of a petition date and a Chapter 11 filing. So we really need to be focused on the application of state law to this question, and the state laws are robust in this area. So let's focus on the state law and make sure that it's being applied as intended.
Okay. Do we have a microphone that can go around for any questions? Please, yep, I'll give it mine. Just let us know.
Yes.
Anyone have a question? Please.
As it applies here, do you have any comments on the Theranos case relating to our subject?
No. No.
Okay, great, thank you. Anyone else?
I mean, it appears that she's a bad actor, right? And I think that's actually one of, we didn't really get into sort of the risks posed to being an independent director, but one of the risks that we have to take on is the potential of getting involved in a situation in which either the management team or the board, are, bad actors, or you get into a situation where, governance is dysfunctional. But if I would not want to be an independent director in Theranos right now.
Yeah, that's more of a question of board composition from the start, right? Yeah, going into that situation. Sorry, I would say that's more of a question of board composition at the start, that there wasn't the right questioning of what actually was happening, right? And so, Sherman, then that's indicated the problem that you have, and then saying, Sherman or myself, would you like to take a board seat on Theranos as they're going through a process? I'd say I'd have to look at all the other advisors that were there, that I knew that the right team was there running the process to work that enterprise through.
I mean, nobody on that board evidently went to like Walgreens, and took the test to see if the product actually worked.
Yeah, so I don't know if they were bad actors in the sense of, bad intention. They were certainly.
That's currently being litigated.
Yeah, right. They were certainly, dazzled by her sheer force of personality and didn't do the job that good independent directors do.
Generally good directors.
Yes.
In this particular,
Exactly.
In this particular case.
Try the product. See if it works.
Any other
Well,
questions?
they just didn't exercise their duty of care.
Yes.
Like, they failed.
They failed.
That's clear.
Any other questions in the room? We're happy to answer one more question. Maybe.
Hi.
Go ahead.
Hi,
Harold?
it's Harold. Hi. I just want to ask the question that's sort of out there, which is situations where independent directors have sort of been in the middle of negotiating ultimate plans. There's some people like the plans, some who don't, but then the issue comes up about their independence, because the argument is made that the plan that's presented is basically a compromise that was fairly done among all these parties. And then I think the issue becomes how independent really were the independent directors who negotiated it. How do you view that argument? And second, how do you view the various ways of protecting, of making sure that the independent directors look as independent as possible in the process?
Listen, anytime, and those are the hardest cases, I think the ones that Daryl brought up are the cases where there's you have a company that needs to move for whatever reason through a restructuring process quickly, risk to the business is perceived to be that we have to do this, and there has to be effectively a private settlement cut that's subject to later court scrutiny. And I will tell you that you have to be squeaky clean on the process. That means that you're getting a director that really doesn't have any relationship to the sponsor or other parties. You make sure that there's separate counsel, obviously, on each side of the transaction. And importantly, you can't bring in the independent director after something's already been started to negotiate. They have to be in there, and we insist on this. You have to be there, and that person has to be involved, from the start of it. There's going to be subsequent court scrutiny that will, and creditor scrutiny that will be involved. If there's creditors that are organized at the time, we think it's extremely helpful if they're involved in the discussions, especially if there's a fulcrum security that you can readily point to also assist with that. But those are difficult circumstances that are going to get a lot of attention in a subsequent Chapter 11 case.
Yeah, just to add to that, I agree with everything that Ray said. I mean, in addition, you want to look for market checks to employ in the situation. So, speaking of the financial advisors, what other alternatives have been considered? Is anybody else willing to put in money on better terms? What's the sponsor getting out of it? And is there a better deal out there? Continually be asking and pushing that question. Is there a better deal out there?
Thank you. Any more? I think we have time for just one more question from the audience and then concluding remarks. Okay, going once. Very good. Concluding remarks from the panel. What do you think the next steps are going to be in terms of the evolution of the role of the independent director, if you had to use your crystal ball and tell me what it looks like 5 to 10 years from now? What are the things that you think are going to change and why? Not a prepared question. Thank you.
I'm happy to start.
Go ahead.
I think what you're going to see is an evolution of what you're seeing right now in the process where the creditors are exerting more influence. I think that the shift that's happened at the firms where they're servicing across debtor and creditor, they're more open to working with creditors to try to improve the process. And improving the process is multifold. It's also the appointment of independents to help the process, but it's also how you think about fees in the process and how you can move things further. One thing is that we have gotten away from what the restructuring or bankruptcy process is for, is to fix the enterprise. There's a lot of prearranged, pre-negotiated, where you're going very fast and haven't addressed the issues with the business, right? Having lived on the investing side, the process that we have, the sections of the code that allow you to change the business during the process will outweigh the cost of the professionals if people just understand exactly what's happening. But the creditors will need to exert influence to work with people. And you're seeing in the restructuring world now, the debtor side counsel that are good, like Array, they're more open to saying what's best for the enterprise, which is ultimately what's best for the new owner, and let's run the process that way.
Thank you. Anyone else?
I think we'll continue to see it play out in the courts. People are going to press this issue, and I think ultimately people are going to have to come back to what the bankruptcy code's actually for. But there's going to be, our share of litigation, I think, over the near term on this issue. But if I had a crystal ball, I'd say there's not some type of change to the underlying governance structure of companies that are going into distress that's covered by state law.
Yeah, look, I think the U.S. bankruptcy process is the best model for this type of situation in the world. I don't think it's broken, so I don't think it needs to be fixed. But yes, I think there will be continued evolution of how creditors think about the process and how creditors react and the things they will negotiate around independent directors, as we move forward. I see more and more when lenders are providing capital in sort of rescue or extraordinary situations, they're negotiating, the ability for independent directors to be placed on the board, and I see that more and more.
Yeah, I think we'll continue to see a continued evolution of private capital, so that sitting under the same umbrella enterprise will be a private equity side and a private credit side. And private credit is evolving so that we see instruments that are kind of hybrid-like in that they have equity-like features to them, and that'll continue to evolve.
Okay. Well, thank you all for participating today. Thanks to the audience for your involvement. We appreciate it, and we'll be happy to do this another time again. Thank you.
And thank you, Didier.